Raising capital for an opportunity zone project is not easy, and on top of that, there are many legal complexities that you need to consider. Welcome to the Opportunity Zones podcast. I'm Jimmy Atkinson, and joining me on the show today is Andrew Doup, founder of Syndication Counsel. Andrew's joining us today from Columbus, Ohio. Andrew, it's great to see you. Thanks for coming back on the show. Welcome.
Thanks for having me, Jimmy. I'm happy to be here.
Absolutely. Well, it's always great talking with you. Andrew, if I can introduce yourself for just a moment here. Andrew, for those who don't know, he's a nationally renowned Opportunity Zones attorney. He has a background in securities law, and he's also a member of my Opportunity Zones mastermind group, OZ Insiders. Andrew, I want to talk about securities law and how it can sometimes impact capital formation of qualified opportunity funds and the underlying qualified opportunity zone businesses or projects that are held by such funds. I want to talk about that in a moment. But first, in case any of our audience is not familiar with you and Syndication Counsel, can you tell us a little bit about yourself and your firm?
Sure, happy to. So just by way of a quick introduction, I've been advising entrepreneurs on how to navigate compliance with federal and state securities laws to raise investor capital with confidence. Opportunity zones are a natural extension of that practice, and it has been so much fun working with, who I would describe as next generation entrepreneurs. As you mentioned, raising capital is not easy unless you're already wealthy or well connected. And so, what I like about opportunity zones is that these tax incentives are designed to incentivize the investment of private capital into the communities that need it most. Now, opportunity zones have a lot of barriers to break in order to increase investor confidence. And securities laws are hopefully an area where I can reduce that burden, both for entrepreneurs, for fund managers, developers, as well as investors.
Right. Now, whether you're a developer or a sponsor or an investor, there are times when securities law can impact capital formation in opportunity zone projects, but that's not always the case. So can you explain, first of all, before we get into the nitty gritty of securities law, first of all, when exactly does securities law come into play? What type of opportunity zone project does it need to be? When should I be concerned as an opportunity zone participant?
Yeah, that's a great question because the general rule is that if you have passive investor participation in your business venture, whether it's organized as a QOF or a QOZB, then you're going to need a strategy in place to manage your resulting federal and state securities liability risk. The general rule is that if all the partners involved in a venture are actively involved with the management of that venture, then there really is no risk that's inherent with passive participation. But it's those risks that are why securities laws are in place and why they are regulated. Is because the nature of the passive investment, the government has in place a regulatory regime that both promotes capital formation in markets like opportunity zones, while also protecting investors from things like fraud. So again, if you're involved with a QOF or a QOZB and you want to raise investor capital to capitalize your business plan, then you're going to want to think about how to manage your resulting securities liability risk.
Okay, so if I have a single asset in an opportunity zone that I'm raising capital for, maybe it's a ground up construction of a new apartment building, and it's the only project I'm working on. I've set it up as a qualified opportunity zone business. I'm going to look for funds to invest into that qualified opportunity zone business. I'm going to go seek capital from outside passive investors. The qualified opportunity funds themselves will be passive. That probably rises to the level of a security that you need to make sure you're in compliance with securities law. Or conversely, maybe I've already established a fund. Maybe it's a single syndication, or maybe it's a multi-asset portfolio, and I've got a qualified opportunity fund, and I'm looking for just LPs to come directly into that fund. In either case, is it a security?
Yeah, That's right in both cases. And you used an acronym that is commonly used when you're signaling a passive investment, and that's LP. As a
Mm.
limited partner, you're not a general partner. And so what that means is you're relying on the general partner or the GP to put your money to work. And that's certainly the case for scenarios where LP capital is involved.
Now, there's some scenarios though where maybe I don't need any LP capital. Maybe I'm funding the entire deal myself, or maybe my wife and I are going to fund the deal, or maybe, me and one or two other business partners will fund the deal. Maybe we have the few $1 million we need. In that case, does securities law come into play there, or is it not a security if we're all GPs in the entity?
Yeah, that's right. And that's the primary distinction, is if all of the people that are involved share in management responsibility and decision-making authority of the business venture, then they're not going to need the presumption is they're not going to need the protection that securities laws provide because they have equal access to information. They have equal decision-making authority. They all have skin in the game, and they're all equally responsible for the profit or the loss.
Yeah, we should never fail to mention that sometimes these businesses actually do lose money. We want them all to be profitable, right? And especially in the case of opportunity zone deals, the tax benefit only kicks in if it is profitable. So these securities laws, Andrew, I should mention, in case our audience is not fully aware, they don't pertain solely to opportunity zone deals, although we're talking about them in the context of raising capital for opportunity zone deals today for our purposes on this show. But these laws predate opportunity zones by almost 100 years. Is that right? And can you tell us how exactly are passive investments in qualified opportunity funds and qualified opportunity zone businesses regulated by law?
Yeah. So again, the purpose of securities regulation is to both facilitate capital formation, but also to protect investors from fraud. These regulatory regimes, they were created, after the Great Depression. Balancing those two interests, the SEC has made clear, and there was some uncertainty about this at the beginning of the opportunity zones economy, but the SEC made clear in pretty short order that passive interests in QOFs and QOZBs are going to be regulated and are regulated as securities, meaning they're subject to both federal and state laws that govern really three activities. The first one is the offer and sale and resale of securities. That activity is regulated by what's called the Securities Act of 1933. The second primary activity is investing in securities. So you've already pooled investor equity. How are you going to invest it? That activity may be regulated by the Investment Company Act. Third, giving advice about investing in securities is a third activity that's going to be governed and regulated by federal and state securities laws. And the primary legislation there is referred to as the Investment Advisors Act of 1940. And so at Syndication Council, we primarily focus on that first one, helping entrepreneurs navigate compliance with the Securities Act of 1933 so that they can raise investor capital with confidence.
Good. And so what happens if an individual, maybe somebody raising capital from investors for an opportunity zone project, is found to be not compliant with these securities laws? I mean, what could potentially happen? Also, how often does it happen that somebody gets into trouble, and who are you getting in trouble with? I've got a lot of questions here.
Yeah,
What are the penalties? What are the punishments if you're caught violating some of these securities laws?
yeah. So, we've talked about securities regulation, but, what's the risk of non-compliance with the rules? And, the reason why people pay attention to securities compliance is because the risks are onerous. They include both civil and criminal liability. So, in the context of compliance with tax rules, we're talking more than just tax penalties here. We're talking about, not just civil penalties, but also the prospect of criminal prosecution. And I can tell you the Securities and Exchange Commission. This is the federal agency that regulates the offer and sale of securities. They had the most enforcement actions in 2024 than they have, I think, maybe ever. I just saw a headline about this, but they are extremely concerned with the influence of social media on investor behavior. This compliance regime is not just theoretical. This is real, and it's something that we see in my practice every day. And big part of that maybe because I'm in the algorithm that feeds me this information, but it's hard not to pay attention to when you just consider the onerous risk of liability.
No, I think that makes sense though, Andrew, because a few things have transformed private markets over the past, I'd say 10 plus years. One, there's been a lot of democratization of access to these private markets. I mean, you know, a generation or two ago, you couldn't really participate in a real estate syndication or a private fund syndication if you were a small Main Street investor. That's all changed dramatically within the last 10 plus years. There's a lot more access for smaller investors now. And then two, you mentioned these social media influencers. People are getting their information from a much more fractured landscape, a much broader variety of sources, and not all of them are reputable. TikTok comes to mind, Facebook, Instagram, Twitter, YouTube, you name it. And we're on a few of those platforms, and we think the information we're putting out is pretty good, but not everybody's information is all that sound. So if you find a big TikTok influencer who's trying to pump you an offering into XYZ Co or something like that. That none of this stuff existed 10 years ago. So I think those two factors are leading a lot of investors into making some rather dubious investment decisions, unfortunately. And I guess it is time for the SEC to crack down on it. I wonder if that might change with the new Trump administration coming into office a week or so ago, and if he has a different outlook on things, or if his SEC might do things differently, or
Yeah.
there's also talk about the TikTok being banned or not being banned. I think a lot may change still to come
Yeah.
going forward, Andrew. But
Yeah.
get your reaction to that first.
Yeah, I think it's still too early to tell. I mean, a lot of the SEC staff under the prior administration, they've already left the job, so take that as an indicator of what it's worth. But that's not going to change the mission of the SEC or for any state securities regulator, which, again, is not just protecting investors from fraud, but it's also promoting efficient capital markets and promoting capital formation for the places that need it most, like opportunity zones.
Right.
But we talked about the risk of civil and criminal liability. When it comes to securities compliance, an ounce of prevention is worth a pound of remedy, 10 times over. I just think I want to underscore the importance if raising passive investor equity is part of your OZ strategy, whether it's raised by a QOZB or a QOF. Then this is going to be something that you want to talk to your advisors about because cases involving fraud, like those are the easy cases, cases where a sponsor, fabricates documents or lies to their investors. Those are easy cases, but cases don't need to be that egregious to implicate the risk of liability. Because of the second half of that equation, because we've got regulations in place that are designed to protect investors from fraud, they're going to have a cause of action based on a securities claim for something that maybe didn't result in a total loss, but maybe if you're a developer, you promised something, an anticipated return, and the results fell short of the expectations that you set for your investors. That's going to, your investor, may be in a position where they can assert a securities liability claim if they can show a court that, hey, I was promised X, but I didn't get that. I got something less, and I wouldn't have made the investment but for that representation. And those are the more difficult cases. I think those are the more real cases that we want to ensure that we're insulating folks from.
Right. I'm projecting an IRR of 18% over a 10-year hold for my opportunity zone project. But then fast forward 10 years, maybe we only hit a 14% IRR. And I've got a few of my LPs that are a little bit upset about that underperformance. They come to sue me or they take me to securities court. I don't really know what that is or if that's what it's called. Um, that's a real risk as a sponsor or developer of a project who's trying to raise capital for their deal. So what can I do? What can I do to protect myself? Because I don't want to. I'm kind of caught between a rock and a hard place, right? Like I don't want to under promise returns too much because then my deal isn't very enticing. Nobody will invest with me if I'm projecting very conservative IRRs. I don't want to project ridiculously aggressive IRR numbers because those look unrealistic. I want to project something that looks good and is saleable and marketable, and I have a sound case for. But the fact of the matter is, a lot of this stuff sometimes is beyond my control. External factors come into play, and 10 years is a long time to project. So how do I protect myself while also making the security marketable, making the offering marketable to investors?
I think it's really important that we, set the table for this discussion because the most important part is that yes, the risk of securities liability is onerous. However, these rules have been in place for nearly 100 years now. And the reality is that entrepreneurs and private investors venture into business partnerships every day. And that's why we formed a law firm to focus specifically on identifying and managing this liability risk. In I've got some numbers here to help put this into context. But in 2019, U.S. companies raised 2.1 trillion through what we call exempt securities offerings. So anything short of a publicly traded company, that is 70% of the total market for capital formation in that year. So the majority of private capital, of investment capital that's raised, is raised privately and it's raised in compliance with this exempt securities offering framework. So what are the rules that are in place? Generally what I tell clients is that it's really easy to get confused by the different exemptions that are out there, the different securities offerings exemptions. But the common denomination is two rules: disclosure and consent. You want to disclose to your investors not just the terms of the offering, but also the risks that are material to an informed investment decision. All right, so disclosure. Let's talk about consent. If anything that was disclosed to your investors errs or deviates from operations, from reality, which is going to happen, right? In business, this is going to happen, and it should be expected to happen. You disclose that to your investors, but you also get their approval for any changes or tweaks that you need to make to the business plan, so that they are fully informed of the change and that they're on board with your plan to fix it. Disclosure is pretty, it's pretty easy to think about that and to do it up front. But while you are managing passive investor equity, you have to remember your obligation to keep your investors informed of any material changes and to get their approval for changing course if the business plan isn't materializing according to your projections, so that they consent to that.
And can that sometimes be, I think we're going to talk about this a little bit later, so sorry if I'm jumping the gun, but can that be outlined in an operating agreement that may give the discretion of investment decisions to the GPs involved? And or how do you usually go about getting consent from investors? Can it be done automatically, or do you actually have to draft them a letter that they need to execute and send back to you every time you need to make some sort of change in your strategy?
Yeah. So the starting point for this answer is going to be governed by the LLC agreement or the operating agreement in the case of a limited liability company, or a QOF and QEZB that's organized as an LLC. When I work with clients on an exempt securities offering, the first thing we do is talk about what rights they want to offer to their investors. Because really, if you're an investor, yes, you're investing into a business plan. Yes, you're investing into the management team behind the business plan. But in exchange for that check, you're going to be purchasing rights in exchange. So what rights are you purchasing? You're purchasing information rights. You're purchasing economic rights, of course. You're also purchasing transfer rights. Under what conditions can you transfer your interest if you decide that it's time for you to exit? And then you're also purchasing voting rights. So, those are generally the four categories of rights that you're going to want to discuss with your advisor when you're organizing a syndication or a private fund, any investment vehicle that is going to have passive investor participation, because that's the first place you're going to look for the answer. And in some cases, you're going to offer your investors an approval right on some decisions, but maybe not others. Maybe your investors don't really want to be involved in operational decision making. In fact, that's the case for most investors, and that's okay because that's what they consent to at the time they give you their money. But they also gave you the money based on a set of assumptions that you had in your investor presentation materials, and but for those assumptions, they wouldn't have made their investment. So again, if something changes with the business plan, review your operating agreement, understand what rights you offered to your investors when they made their investment, and then give them the right to exercise, or give them the ability to exercise that right when it's warranted. And stepping back from the operating agreement, if things begin to go south, and this is really where sponsors begin to get in trouble from a regulatory perspective, when things if or when things go south, they panic, and they think that it's better to try to fix it without their LPs being on board with it. That's really where things where your securities liability risk just skyrockets, because yes, you may have disclosed to your investors at the outset, when you took their money, but you didn't disclose to your investors the change to the business plan, and you certainly didn't get their consent when you decided to change your approach. So coming back to consent and disclosure just being the foundational principles of managing securities compliance.
Right. So we talked quite a bit about consent last few minutes. What about disclosure? How do you disclose to investors or potential investors, and what are you disclosing exactly?
Yeah. So there is a legal instrument that's used to disclose to investors the terms of the offering as well as the risks that are material to an informed investment decision. This is referred to as a private placement memorandum, or a PPM. Some folks also call it an offering circular. You don't need a PPM or an offering circular. You just need to make sure that the disclosure happens, whatever it is that you call it. Have the disclosures somewhere and make sure that it's provided to your investors so that they have an opportunity to review it, so that they have an opportunity to weigh the merits and the risks, and so that they are in a position where they can confidently say that they're making an informed investment decision. And as a sponsor, that's the position that you want to put your LPs in, because you want to have a fully informed LP. You want to have good LPs, because they are going to be able to contribute to the success of the venture as well.
And so let's talk about PPMs for a minute here. What risks specifically should be disclosed in a PPM? How long should this document be? And is it possible to just use, I actually got this question from a potential new sponsor just a couple weeks ago, Andrew. He asked me, is there some sort of boilerplate document I can start with, and can I just do my own PPM, or do I really need to hire an attorney to put one together for me?
Yeah, you generally are going to want to have securities counsel, just generally, and that's going to be a discussion that you should have with your securities counsel. My approach is to work very closely with my clients, because I know, if I wrote their operating agreement, I know, what risks should be disclosed in the PPM just based on the terms that were offered to the investors. but the client knows the asset better than legal counsel does. The client knows the industry better than legal counsel does. So, um, my expectation and the expectations that I set for my clients is that it's going to be a team effort, and not just the client or their advisors are going to have, are going to be able to offer a comprehensive set of disclosures to investors. They're going to have to work together.
And a PPM, typically, how big are these things? And does anybody actually read them? Is my
Yeah,
question.
yeah, so it's kind of funny to me, but PPMs, like I've read PPMs that have been hundreds of pages, and I haven't been a lawyer my whole life. This is my second career. So with that perspective, my view is 200-page document doesn't tell anyone anything. They're going to be less informed than they would be with a disclosure document that what was not boilerplate, but actually spoke to the real risks that are material to an informed investment decision. So they can be voluminous. They can be hundreds of pages. My advice to clients is let's keep all this stuff about the team, about the metrics. Let's keep that in the investor deck. Keep it out of the legal disclosure document, because you may want to update that. As your assumptions change. Provide that to your LPs and disclose to them the changes that were made. But let's keep the PPM as concise and as accurate as we can so that it's useful, both for the prospective investor as well as for their advisors.
Good. Okay, so we've talked about a couple of really important documents that a sponsor or developer should have when he takes the project to market to raise capital from passive investors. We've talked about the operating agreement or LLC agreement, the governing document essentially of the entity that is holding the business. And then we've also talked about the private placement memorandum or the disclosure document. There's a third document though that's possibly also very important, which is the subscription agreement, which details how exactly the investor is coming into the fund as an investor, and I think sometimes includes wiring instructions. Or tell us about that third and final document, the
Yeah,
subscription agreement.
yeah, you nailed it. So whereas the PPM is a legal instrument that discloses the offering terms and risks material to an informed investment decision, a subscription agreement is a legal instrument used to close on investor checks or investor wires, but more importantly, to allocate the risk of securities liability away from the issuer or the manager of the issuer, the sponsor, and onto your investors as informed decision makers. Because in that subscription agreement is they're going to make all the reps and warranties that you need them to make in order for your securities offering to be compliant with the Securities Act of 1933. And there were different pathways that you can take. There were many different exemptions that you can take depending on the facts and circumstances of your deal and of your prospective investors or of the investor demographic that you want to target. And that may be a subject for a separate podcast episode, Jimmy. But generally, if you want to cast the widest net possible to capitalize your business plan, then you're probably going to want to file a Form D with the Securities and Exchange Commission as well. And the reason why is because that Form D filing is what preempts state registration requirements. And so that's going to enable you to cast the widest net possible without having to worry about the registration requirements that are imposed by any given state where an investor resides. So we've talked about three instruments. There's also a fourth deliverable, and that is the SEC filing.
Good. And I think we should get you back on the podcast at some point down the road here to talk about different ways of filing with the SEC, because there's numerous ways to do it, and there's a lot of nuance into even just Reg D filing. There's a lot of different choices that you have. We'll save that for another episode later on. Andrew, we've talked quite a bit about securities law implications from the perspective of an issuer or a developer or a sponsor. We're kind of using those terms interchangeably. Somebody who's raising capital from investors for the purpose of completing an opportunity zone project. And we're running out of time, but just in the last couple of minutes we have here, can you talk about from an investor's perspective now, if you're being solicited for participation in a private fund or a real estate syndication, maybe it's an OZ deal, maybe it's not, what should you typically be on the lookout for?
Yeah, here's what you want to do. If you're an investor, you want to ask for the offering documents, because the offering documents can mean a lot of different things. It can include a PPM, it can include an investor deck, it has to include the operating agreement, or it can be any combination of one or more of those documents. But if your sponsor doesn't know what your offering documents are, then that's going to be a red flag as you work through your due diligence process, because the business plan may look great, but if they aren't offering and selling participation by passive investors in compliance with these federal and state securities laws, then that could unwittingly create a huge regulatory liability, for the partnership. And beyond that, if they do respond with the offering documents, and it includes an operating agreement, a PPM, and a subscription agreement, then you're going to know that you've got a team, that your sponsor has a team of advisors that are behind them and are helping them identify and navigate these securities compliance requirements.
Always good to be on the lookout for those offering documents. Andrew, thanks so much for your participation today here on this podcast. Your expertise has been great. I love getting these insights from you. We're gonna get you back on at a later date to discuss some of these other issues. But for now, we'll cut you loose. But before I let you go, where can our listeners go if they're interested in learning more about you and Syndication Counsel?
You can find us online at syndicationcounsel.com. Find me on LinkedIn, or just shoot me an email, andrew@syndicationcounsel.com. Happy to talk to your audience.
Perfect. And for my audience out there today, I will, as always, have show notes available at opportunityzones.com/podcast. And there I'll have links to all of the resources that Andrew and I discussed on today's show. And I'll make sure to link to Syndication Counsel and his email address as well. Be sure to also subscribe to us on YouTube or your favorite podcast listening platform to always get the latest episodes. And if you're watching us on YouTube right now and you like this episode, give us a thumbs up. It helps out quite a bit. Andrew, thanks again. Really appreciate your time.
Thanks for having me, Jimmy.